My name is Professor Mike Newton from Vanderbilt University Law School in Nashville, Tennessee. It really is a joy and a privilege to get to speak to you today. Today, we're going to talk about rights of prisoners of war, and in particular, the right of the prisoner of war in a legitimate status to have the assistance of qualified and competent counsel. I'm going to break down the discussion today into about 5 key areas: introduction of the key big issues, followed by a pretty good discussion of the applicability of the Geneva Conventions and the particularized protections, followed by a longer discussion, the longest discussion actually, on the precise substantive issues that I've encountered in the defense of prisoners of war and are relevant straight from the Geneva Conventions. Then we will sort of tail down. We'll do a little bit about sentencing. I want to talk about sentencing and then do a couple of big picture issues. With that said, though, I just want to emphasize right up front that we in the larger legal community are honored to serve you. I think we share a great deal of commonality in defense of the respect and the rule of law. I think it's particularly important now during an ongoing armed conflict that we comply with the conventions on both sides, that the conduct of hostilities be conducted lawfully. We know that's one problem, but it's incumbent upon us as the legal professionals to make sure that the adjudication of those cases is done strictly in accordance with law and the requirements of the Ukrainian Criminal Procedure Code. And with that, I want to introduce the key themes. And one thing I forgot to add, I will also send about a 40-page substantive outline with every legal citation that I will give you as we talk. So if you want to take notes and have precise provisions of particular conventions written down, great. Rest assured, however, that I will provide authorities with every citation and a full written document that summarizes everything I'm going to say to you today. So right off the bat, I promised an introduction on the big core issues. I want to stress that the provision of qualified defense counsel is important for 3 fundamental reasons, which simply cannot be avoided. Item first, Article 130 of the Third Geneva Convention, which is the Geneva Convention for the Treatment of Prisoners of War from 1949, specifically says that the denial of a fair trial of a prisoner of war is itself a grave breach of the Geneva Conventions. Now, this is very important because we rightfully want to hold the wrongdoers accountable when they've targeted civilian property or when they have committed any number of other war crimes. But on the flip side, it's vitally important to recognize that the Geneva Convention uses exactly the same characteristic, a grave breach, a serious violation of the conventions, to deprive a prisoner of war of the benefits of a fair and regular trial. And I'll just give you the language of the law. That's Article 130 imposes the legal duty. Article 129 of the same convention says that states party, which would be Ukraine in this case, have a duty to enact any legislation necessary to provide effective penal sanctions. Effective sanctions are defined as those that are adjudicated in accordance with the rule of law. And by definition, that means the provision of qualified and competent defense counsel, which leads me to the second big point. The right to fair trial includes a competent counsel. Article 105 of the convention specifically says that prisoners of war are to be tried under the same rules and to the same standards and the same even-handed across the board processes as domestic soldiers. I've termed this, and there's some references in international law, this is called the assimilation principle. The idea is that prisoners of war are simply absorbed or assimilated into the established legal system. The trick, though, is that there are these additional overlays that come from international law because of the status as a prisoner of war, which is an objective status. They also get an additional layer of benefits if the domestic law is deficient, then the additional layer of international law must be a gap filler designed to facilitate the full achievement of prisoner of war rights. So the trick is that a competent defense counsel is defined as a counsel who always acts in accordance with the good faith performance of their duties on behalf of the law, on behalf of the nation state, but particularly on behalf of their client, who happens to be a prisoner of war. So a failure of competence or due diligence on the part of defense counsel logically deprives that person, even though they're a prisoner of war, of the right to a fair trial under the convention. That in and of itself, as I just said, constitutes a grave breach. So from the defense perspective, this actually is a very patriotic duty. I think it's important to recognize that. Doing due diligence, doing your very best to represent the law and to ensure that the process is fairly adjudicated and that all of the relevant substantive legal issues are argued, is actually a patriotic duty in the sense that it prevents further recriminations against Ukraine itself. So your role in the process as defense counsel, in my mind, is vitally important, which leads me to the third, very subtle but overarching big picture connection. And it's this idea that if we simply presumed guilt on behalf of prisoners of war who are non-Ukrainian nationals, so what we're saying is typically Russian citizens, or, as we'll discuss in a few minutes, some other person who happens to assist Russian citizens or Russian military. If we simply assume that they are not entitled to the presumption of innocence, or that for some reason, in which of course you recognize would be highly inappropriate, they can have a conviction based on something below evidence beyond a reasonable doubt. What we're actually really doing is subjecting that class of people to collective punishment or discriminatory conduct. And I want to be clear that, again, this is captured in the Geneva Conventions, but in this context, it would also be captured under the relevant case law from the European Court of Human Rights. Collective punishments absolutely are a violation both of the Geneva Conventions and of relevant human rights law. Article 98 of the Convention says the following: no prisoner of war may be convicted without having had an opportunity to present his defense and the assistance of qualified advocate or counsel. So it's twofold. In doing your patriotic duty and in upholding your obligation to serve the integrity of the law, what you're actually doing in the larger sense is saving Ukraine itself from recriminations, and in the larger sense, in the European human rights context, from the possibility of having to pay damages. This is vitally important, and I think it's a necessary part of Ukraine acting in good faith to conduct the totality of hostilities in accordance with the larger body of international and domestic law that's applicable. This was a particular issue, and in the handout that I will send to you, this was litigated in the Katanga case at the International Criminal Court. And so there's an extensive amount of international jurisprudence that I have cited for you in the handout that will accompany this discussion. The other thing that I wanted to highlight before we move to the broader applicability of the Geneva Conventions is the notion that Article 87 of the Geneva Conventions prohibits exactly what I've just said, collective punishment. Now, this goes back to the very beginning of the field of international criminal law. What we're doing in international criminal law, and in fact, what the Ukrainian Criminal Procedure Code does in Article 438, is to transpose or to layer international law into the system of Ukrainian domestic law. That's a pattern of countries all around the world. Many, many countries have commonly done that. The trick is that in doing that, there's a duty to ensure that both bodies of law are respected. So what that means in practice is that the provision of adequate defense is vitally important at both levels. So Article 16 of the Geneva Convention requires prisoners of war to be treated without adverse distinction of any sort based on race, nationality, religious or political opinions, or any other distinction. And this prohibition on non-discriminatory application of the law should sound familiar to any human rights practitioner in the world. That's the very basis of human rights law. This concept in international criminal law, however, goes back to Nuremberg era, post-World War, the idea of individual responsibility. Any prisoner of war can only be lawfully convicted based on what he or she has done and based on a quantum of evidence that proves guilt and each and every step beyond a reasonable doubt. And it is your challenge and your professional duty to ensure that that system works. Now, those are the big picture baselines. Let me talk further now about the larger applicability of the Geneva Conventions. I think it's important to understand why the Geneva Conventions apply. I'll discuss the binding nature and particularly this idea of the application to what international law terms combatants. I'm sure that you all have heard that term and are familiar with the concept combatants. It is a unique concept applicable only in the context of an international armed conflict. So combatants, and therefore combatant immunity, only applies at the international armed conflict to participants in that international armed conflict. There's a separate category of criminal law that comes from the Geneva Conventions, particularly in this case, the protocols, Protocol 1, to which Ukraine is a party, and it's the idea of what's called a direct participation in hostilities. This is applicable to normal civilians who would be fully protected both by human rights law, as I've previously said, and by the Geneva Conventions. And I want to explain a little bit of the intricacies there, because sometimes the distinction between prisoners of war, combatants, or civilians, or directly participants in hostilities may mean the difference in the appropriate jurisdiction, and in particular, the appropriate criminal charge to be brought. So it's always a perfectly valid defense motion to say, Your Honor, I request a jurisdictional change because you've charged this person in the wrong place for a set of crimes to which they would not otherwise be applicable. That's why these distinctions about the applicability of the law become important. So let me start with this distinction. As I've already said, the Geneva Conventions of 1949 have an entire convention specifically designated to the concept of prisoners of war, to their rights, to the duties of the party that captures them. And it defines a prisoner of war at the outset in Article 4 very bluntly. It simply says persons who have fallen into the hands of a party of which they are not nationals. In other words, an enemy party during an international armed conflict. That's Article 4. The broadest class in Article 4A2 simply says the armed forces of a state. Well, that's fairly straightforward. You have a Russian participant who's fighting in Ukraine, easy application of that. So that's an easy question. When they're conducting conflict, they are combatants. When they cease to be conducting conflict, they're what's called protected persons. And this is an important concept because they're protected at that point by the full force of the Third Geneva Convention. So as a prisoner of war, you're a protected person. And that's, as a legal matter, why all of these rights and duties, the right to counsel, the right to a fair trial, the right to be free of torture or cruel or inhuman degrading treatment, the right to have no hostage taking against their family or anybody else, and in particular, the right to be adjudicated fairly by an impartial, independent court. That's why all those rights come into play for combatants. because they're protected persons. And the law, in this case, the Third Geneva Convention, protects them. On the other side of that, and I think this is very important to say now, and then I'll come back to this because it's a vitally important concept. When we talk about substantive protections, I'll say it this way. Combatants who are lawfully participating in hostilities, conducting lawful combat, using lawful mechanisms, are entitled to what's called combatant immunity. We only prosecute them when they violate the applicable body of the laws of war, the laws and customs of war. Now, combatant immunity is slightly different in the sense that in this context, it is a specific rule that does not flow from the precise language of the Geneva Conventions. It is implicit. It is infused. It is the very background predicate from which the entire Third Geneva Convention comes. So this becomes a substantive issue at trial, of course, and an issue which I expect to be litigated very stringently by the defense in almost every case. And the issue is this: I may be a prisoner of war, therefore I have procedural rights to fair trial, but I also have the right to combatant immunity. And therefore, if you can't specifically prove that I violated the Geneva Conventions beyond a reasonable doubt, then I'm entitled to not even be charged because I have combatant immunity. This is slightly different from a substantive defense where a prosecutor makes an allegation and I rebut that factual allegation. Here, the argument is much bigger and much more significant because the argument is, as a combatant, I have the lawful right under international law to conduct hostilities, provided that I do so lawfully in accordance with the law. And when I talk about substantive legal issues, I want to dwell on this because there are ambiguities that need to be exploited by a vigilant defense counsel. But so that's a substantive defense that is intimately, deeply connected to the concept of combatant immunity. And I will come back to that. So we've already talked about combatants and the rights that they're accrued to enjoy. The commentary also specifically relates in its extended form to armed forces or groups or non-state actors who are specifically incorporated into the armed forces of another state. And this is important because you may have some civilians who would claim civilian status who meet those criteria and therefore become prisoners of war. Others may fall short of those criteria. So it's important to understand those provisions and to understand where they come from and why. The reality is, though, that the commentaries from the International Committee of the Red Cross give you a great deal of granular detail as a counsel exactly how to make these arguments. And I'll just give you a few examples. Again, the specific citations and the language is all extracted for your use in the handout that I will provide. So paragraph 1005 of the newest commentary gives you a two-part test. And again, just to be clear, what we're talking about is the ability of civilians to be incorporated into the armed forces of a state, almost incorporated by reference, if you will, and therefore, even though they still have a civilian status, they become combatants. And as combatants are therefore entitled to all the rights and benefits that would flow as if they were a formal member of the armed forces of a state. So two-part test from the ICRC commentary. Item first, the group must in fact fight on behalf of the enemy. So moral support, propaganda, et cetera, is insufficient. It has to be a fighting role. It has to be a role directly related to the hostilities. And second, the state party, here think about ownership or agency, must accept both the fighting role of that group and the fact that the fighting is done on their behalf. So think of it like this: civilian groups that are facilitating the role of an invader or the role of the nation state that's on the opposing side of the conflict have no rights of their own. The rights that they get actually flow from, as prisoners of war anyway, the consent of the other state. So the incorporation of that irregular group into the armed forces of a state. For example, in much of the case law, one of the classic tests is if I have a planning officer or a logistics officer who is coordinating movements between the formal members of the armed forces of a state who are clearly combatants and the informal, irregular groups in a way that helps ensure a unity of operation, that would be sufficient to make them combatants because they're now incorporated. And again, just to review, because they're combatants, immediately on capture, they get the full range of rights from the Geneva Conventions. If they don't meet these tests, then they are not combatants and therefore strictly civilians. And as civilians, the charges that can be attached to them would be radically different than would be true for combatants. And as the technical reason, the answer is they do not enjoy combatant immunity. Only combatants get combatant immunity. They have no right as civilians in the first place to participate in hostilities. So it would be illogical to charge them with war crimes because technically they're not even covered by the law of war. So what we're looking for is tangible, specific signs of relationship between the state party, incorporation into hostilities, incorporation of those irregular groups into the armed forces of a state in terms of a specific usage in a way that assists and facilitates. And in a military parlance, you might say a force multiplier. So if I have irregulars doing one function on a battlefield, it means that I don't have to worry about fulfilling that exact same function with my own armed forces. A force multiplier is the term. And in that sense, of course, given the fact that I have both an acceptance and an incorporation of that group by the senior officials, I would have combatants, even though they're still civilians and not formally, and upon capture, they would become prisoners of war. It's also worth noting that there's a lot more law specifically applicable to that in the protocol, which could be relevant in some situations, but here I think it's very much on the outside. What I'm giving you is the established 1949 Geneva Convention law, which is most prevalent what you'll see in Ukraine. There's a few potential outlier cases where the council might try to make the argument, and the law here would be Article 43 of Protocol 1. The idea in Article 43 is that I have a combatant, and I have to have met those predicate criteria to become a combatant, right? And then in the conduct of hostilities, there may be some ways in which that combatant doesn't have to meet the classic criteria that are embedded in combatancy. And those criteria are very simple. They come, just like combatant immunity itself, they come from customary international law. And they simply say that you have a fixed and distinctive insignia. The idea there is that combatants are recognizable. They can't intentionally blend into civilians. That helps me because I have a legal duty as a defender to direct my activities only against combatants. It's never lawful for me to intentionally direct activities against civilians. So the duty of a combatant is to distinguish from the civilian population. The second is this related, it's this idea of carrying arms openly. The third is that I have some functioning command authorities, a way of issuing orders and a way of controlling battlefield movements and a way of ensuring good order and discipline. And the last is logical enough because combatants have the legal duty to comply with the laws of war and are only subject to prosecution when they violate those laws of war. The irregular group, to be considered combatants must demonstrate that exact same willingness, the ability and the professed mechanism for complying with the law of war. Technically, because they're not the formal members of the armed force, a violation of any one of those criteria would deprive them of combatant status. As I say, though, this becomes clouded a little bit, and I think they're outlier cases, by Article 43 of the protocol, which simply says that combatants, because of the nature of hostilities, may have some very marginal times during conflict when they don't have to carry arms open as an exception. I want to emphasize that, though. I have not seen much of that in Ukraine, and the legal effect becomes important because as a defense counsel, you would simply be saying, this person is entitled to prisoner of war status for the following reasons, or we accept the fact that they're not entitled to prisoner of war status for the following reasons. And this, as I said, totally relates to the kind of charges that you may apply with respect to a particular person, in addition to the interface between the Geneva Convention applicable to prisoners of war and the normal domestic law applicable to regular civilians at all times and all places under the jurisdiction of Ukraine. Now, this is a distinct concept from the notion, and so if you imagine a bow tie, so combatants on the one hand, civilians on the other, the knot of the bow tie is a very special category, which in Ukraine, I think is a fairly sizable number of people, given my knowledge of the situation. And the importance of this is that they are not combatants. Therefore, they are not prisoners of war. The legal term drawn from the protocol is what's known as civilians directly participating in hostilities, okay? And the idea directly participating in hostilities, you're directly facilitating, but you're not a full combatant either. And this is extensively covered in both human rights law, the 1996 Convention on Civil and Political Rights, and a range of other human rights treaties. They all provide for a fair trial. They all provide for the right to a defense counsel. They all provide for a meaningful opportunity to be informed of the charges against you in a language that you understand. They all provide for an independent and an impartial forum. The trick is that the body of law directly applicable to civilians directly participating in hostilities is a narrower body of law when drawn strictly from the laws of armed conflict. They will get the bulk of their protections from normal human rights law or the normal protections of the Ukrainian Criminal Procedure Code. There is one exception to this that I think is important, and I will in a second go over the range of rights that we're talking about. The one exception here, which sets a foundation, and as a counsel in courtroom, and I appreciate this because I'm a trial counsel, I'm a lawyer, I'm a prosecutor, and I've done some defense work. And so I think it's always important to have a good, clear sense of exactly what rights we're litigating. Those rights are provided very clearly in the melding. When you look at all these different bodies of law together, the list becomes pretty clear. As I've said, impartial, judicial guarantees that are generally recognized as indispensable is the language. So here's the list, right? As I've already said, to be judged by an independent and impartial court, judges who are acting in accordance with the law, not accordance with vengeance, prosecutors and judges who make individual determinations, not collective punishments, but individual responsibility adjudicated under the rule of law. As I've already said, the opportunity to be informed of the charges against you and the cause of the offense alleged in a language that you understand. This is one area where this distinction between a civilian directly participating in hostilities and a prisoner of war becomes vital. Let me say it like this. As a prisoner of war, there is no affirmative duty to charge a person immediately upon arrest. Why? Because we're holding them, as we have a right to do, because they're prisoners of war. They do not automatically have the right to return to hostilities, for example. Contrast that, of course, with the language applicable to civilians, who must be immediately informed, usually within 24 to 48 hours, of the charges against them. And if the prosecutor continues to hold them with no charges, they have the affirmative right to be released. That's why this legal distinction matters between being a civilian, not covered by the larger body of the laws of war, and a combatant, a prisoner of war, who is covered by that body of law. Moving on to the specific rights. All of the rights to a necessary and competent defense. The right to individual penal adjudication. The right to, as we would say in international law, the legality principle. Now, Article 438 on its face is very broad. It simply refers to international treaties that have the consent of the Verkhovna Rada. And that's fine language. But international law has changed in some very material ways. And there may well be cases as a substantive right where a principle that was never actually embedded in a treaty explicitly or implicitly by the Verkhovna Rada is the basis of prosecutorial charges. That becomes an immediate trial issue because it's a violation of human rights. In English, we would say nullum crimen sine lege, no punishment without law. In international law, we call it the legality principle. But that's clearly a form already embedded in Ukrainian procedural law. Here, we're just talking about the specific application of the legality principle within international law of war. I've already mentioned, of course, the right to be presumed innocent, the right to be advised of judicial remedies in this particular language, and of other remedies, and of the time limits within which they may be exercised. Then this makes perfect sense, doesn't it? Because a prisoner of war is being prosecuted in some other system under some other body of law. And so the law doesn't presume that they know everything that they should know or could know about that body of law. It's a completely different system for them and completely different judges, et cetera. So one of the important functions of the court and one of the important functions of counsel is to make sure that they know their full range of rights. Some systems permit guilty pleas, as the Ukrainian system does, others don't. Others have time limits for making motions, some don't, et cetera. There's a whole range of procedural rights that prisoner of war has an absolute right under the Geneva Conventions to be informed about. And then I want to add one specific note. So that's broad treaty law. Those are the broad rights from the Third Geneva Convention. But the other place that I think you should be totally familiar with is Article 75 of Additional Protocol 1. It's a specific add-on protocol, which is what a protocol means, to the Geneva Convention. So it extends that, it repeats that same body of law, no question, with respect to prisoners of war. But then it adds some additive rights. And this is important because Article 75 not only applies to combat, on its face, the text says persons who are not protected by any other provisions of the law, meaning this applies to everybody, regardless of distinctions, provided that the reason they were captured and charged has to do with the conduct of the war. So Article 75 adds three very specific rights to the larger body of rules drawn from the Geneva Convention. It simply says the right to present and examine witnesses. This may be implicit in the larger right to present a defense, but here there's a specific right to witnesses. And defense counsel must be diligent to say that the deprivation of my right to call witnesses is a deprivation of fair trial. And as I've already noted, in the context of a prisoner of war, that deprivation of fair trial on its face becomes another violation of the Geneva Conventions on the part of Ukrainian authorities. Secondly, the right to have the judgment pronounced publicly. And then the third one logically flows out of larger international law. but it's the principle in Latin, what we call ne bis in idem. If you've been convicted or charged in some other setting, then of course you can't be held responsible for that body of law. So we're at about 35 minutes, and I have about 10 minutes of substantive issues that I wanted to prepare you with. And it's basically this concept of the assimilation principle, I've already stated, flows from Article 84. It says that, and I'll read it to you, a prisoner of war shall be tried only by a military court unless the existing laws of the detaining power expressly permit the civil courts to try that person. So that's what's in Ukraine. Because you don't have military courts at the moment, they get the exact same set of procedures as Ukrainian military personnel would get. And this is important because in essence, they're being assimilated or absorbed into the normally pre-existing criminal system. There is one very small exception for disciplinary punishments. And when I think about this, as a defense counsel, it's embedded in Article 82. Article 82 says, in distinction to Article 84, now follow me, that there's an exception for disciplinary punishments. So if I have a person, I can talk to military authorities and avoid a trial on criminal charges by agreeing to some other forms of disciplinary punishments. This makes sense because for prisoners of war, the detaining power is responsible for good order and discipline. So the detaining power, if they decide to charge them criminally, has to use the assimilation principle, those same processes. The exception under Article 82 then, though, is for disciplinary punishment. So as a defense counsel, if I really want to try to avoid a long term of imprisonment for my prisoner of war, I might very well try to persuade a group of military authorities to impose disciplinary punishment. In the United States, we would call this essentially pretrial diversion, a way of avoiding trial, of avoiding criminal charges altogether that would be perfectly legal under the Geneva Conventions. The rest of those principles, ne bis in idem, flow straight from the law and are summarized in a great deal of detail in the handout that I will send you. So let me give you some basics of what it means to have a competent defense. And this is important because these are the specific things that you should be watching for. And this is covered in the ICRC commentaries in paragraph 4114 in great detail. So you can look that up, or you can look in the handout that I will send you. But here's what the ICRC says about the right to present an effective defense. You have to have at least 2 weeks for the opening of the trial, as well as what the language calls necessary facilities to prepare a trial on behalf of the defense. You have the right to freely visit the accused or the defense. You have the right, absolutely, to interview him in private or her in private. And you also have the benefit of all of the same rights all the way through appeal or final petition. In other words, the trial rights of prisoners of war are never over until the very end, the very final action. So in the ICRC commentary, it says that 2 weeks before trial is the absolute minimum, but it gives you a whole range of other factors to assess what the commentary calls, and the ICRC, the overall fairness. So the term from international law is equality of arms. Equality of arms does not require perfect, equal resources. There may be more defense counsel. The prosecutors may have 4 printers, defense only gets 2 printers. So it doesn't have to be perfectly equal. The prosecution may get 50 exhibits allowed at trial. The defense only gets 30. Unless those things result in an unfair trial, then equality of arms does not equal perfect equilibrium. And it's your job as a counsel to try to strike that balance, because there is an absolute guaranteed right to a fair trial. So where those conditions imposed by the court or the conditions in the pretrial period make that an impossible quest, then there's very strong grounds to protest to the judges. And here, then you move into the other range of rights, which should sound very familiar, essentially replicating human rights law. The right to a speedy trial, the right to call witnesses, the right to be absolutely free of coercion or any evidence resulting from coercion or unfair circumstances to be used against the defense, the right to presence at trial. Again, these are trial rights that specifically prevent Ukraine from committing a separate grave breach. In other words, the denial of due process to charged prisoners of war. These rights are mirrored in essence. It's like the two sides of a hand. Human rights law provides this body of rights. The law of war comes and provides an exactly identical body of rights. The only exception there is the ability to be charged very promptly when you're a civilian, while the law of war gives a separate independent authority to detain a person without specific criminal charges. And that's really about the only difference in the overall range of fair trial and due process rights that flow from the law. So I've detailed a great deal of citations in the handout that I will send you, both from the ICRC commentaries and from the case law. So if you wonder about anything I've said, the details, many more details, are provided in the materials that I will send. I want to close by sort of separating a couple of special categories. The Geneva Conventions, Article 108 in particular, make specific protections for the imprisonment of female prisoners, female detainees, or female prisoners of war. And this is important, of course, because the detaining authority, Ukraine in this case, has an overarching duty to prevent any kind of sexual or other violence perpetrated by guards or other inmates. Again, these are rights that accrue to the treatment of that person. And then the extended form of that is the right to be subject to fair trial, but only for violations of the laws of war. And so there's a whole set of rights that apply specifically to female detainees or minor detainees, minor civilian children, even if they're directly participating in hostilities, have a separate subset of rights. So if you have one of those cases, just take note. And what I'm saying is that all the other rights applicable here apply, but there may be some other category of specific rights that are applicable. The last thing I want to say, because I only have about 2.5 minutes given my allocated time, is the idea of appeal. Article 106, every prisoner of war has, in the same manner as members of the armed forces of the detaining power, the right to an appeal or a petition from any sentence pronounced upon him. And here's the key language from the convention. So this is the way you word your motion, with a view towards quashing or revising the sentence or the reopening of the trial. This is why it becomes important to understand the substantive issues from the law of war. Was this a military objective? If so, how do we know? Did it satisfy proportionality? Did it satisfy the duty to take all feasible measures? You have to judge these things from the perspective of your client, the combatant conducting hostilities. And the relevant question is, did what this person did, was it reasonable in light of the information available to them and in a contextual application? Those become wonderful hooks, if you will, for appeals or for retrials. But here's the last thing I wanted to say. The commentaries also emphasize that the right to appeal is not just limited to judicial appeals. They say that when we're talking about prisoners of war, that if there's any other option available to civilians, then that must also be available. So what we're talking about again is this overlay of regular human rights law with applicable Geneva Convention prisoner of war law, different bodies of law. And in some cases they replicate, but where there's an additive right drawn from human rights law, it will also apply to your client. And I could give you other examples. Here's just one. The idea of lex meteor is not in the law of war, but it is absolutely applicable under human rights law. The idea that if there's been some change in the law that decreases my sentence in the interim, we're talking about the merger, the blending of these two bodies of law. And that is about all the time that we had allocated. I want to emphasize that I will send the handout with much more detailed citations and summaries and specific reference quotes from the Geneva Conventions. But I also want to emphasize that I and every other member of the International Bar Association respects your integrity and your commitment to the rule of law here. And as professionals, we stand totally ready to assist you when able and when requested. With that, good luck, and thank you for your service to the rule of law.